Good afternoon. You're all most welcome to Africa Research Institute. Thank you very much indeed for coming. By a strange coincidence, this is our second event in a row with a legal focus following the launch of How Rwanda Judged Its Genocide, Dr. Phil Clark's publication a few months ago. There are representatives from a number of high commissions and from a number of law reform bodies, a number of legal firms, political scientists with an expertise in Malawi, and members of the diaspora. I'm extremely grateful to you all for coming, and I hope that we'll be able to have a lively discussion after the presentations. I am, of course, particularly grateful to Janet Chikaya Banda, the author of Duty of Care. Janet has been, since 2002, the Chief Law Reform Officer of the Malawi Law Commission. In that capacity, she's responsible for all law reform programmes carried out by the Commission and for managing the Commission's Legal Affairs Division. Now, it is Janet who oversaw the constitutional review programme that was authorised by the late President Mutharika in 2004. That was a 2-year constitutional review process, and Janet also authored the report that the review generated, and the report itself was presented to the first National Constitutional Conference. She, I must add as well, collected her PhD yesterday at Birkbeck, so many congratulations to you, Janet. Her doctoral thesis focused on land tenure in sub-Saharan Africa, with a particular focus on the relationship between land law and development. Now, I'll come back to Janet in a minute. Malcolm Macmillan, who is Chief Executive of the Scottish Law Commission, is we hope on his way. The planes coming from Edinburgh were delayed this morning, but I will introduce him now so that he can just fit seamlessly in if he is able to come. Malcolm was, before becoming Chief Executive of the Scottish Law Commission in 2008, he was the Divisional Solicitor for the Rural Affairs Division in the Scottish Legal Directorate. And before that, from 1993 to 2003, the Deputy Legal Secretary to the Lord Advocate in Scotland. Now, his presence was especially welcome and relevant because there are very close ties between the Scottish Law Commission and the Malawi Law Commission, and indeed between the two countries' justice sectors. There are also very close links between the Scottish Law Commission and the Ugandan Law Commission and other law commissions in sub-Saharan Africa. So we're very much hoping that Malcolm is able to come and put what has occurred in Malawi in the way of law reform over the last decade into a sort of regional context. Before we begin in earnest, just a quick word about Africa Research Institute. It's lovely to see regular faces in the audience, but for those of you who haven't attended an event here before, a few words of explanation. We were founded in 2007 as a wholly independent, non-partisan think tank, and our mission essentially is to look for ideas and initiatives with a record of success in Africa, and to draw attention to where new ideas and initiatives might be needed. We have a particular focus on working with practitioners, the people who are doing the doing, and in drawing attention to their work, to the challenges that they have faced, and to what they have achieved in their professional lives. I'm very grateful, we're all very grateful to Richard Smith, our benefactor, who sadly can't be here today. He's actually on an entomological expedition in Zambia, funnily enough, but he sends his very best wishes. Now, coming back to Janet, just as by way of introduction, I'll try and keep it brief. We first met just over a year ago, and quite by chance. And we sat here discussing, actually, Dr. Harry England's Counterpoint, another of our formats, Voices of Disquiet on the Malawian Airwaves, and which we had just published at the time. And one of the things that had interested Janet was Malawians sending in these little slips of paper to the Malawi Broadcasting Corporation with stories on that went out that were then transmitted on this programme, News from Districts, Nkani Zamaboma. Have I said it roughly correctly? Yeah. And Janet said, well, this is very interesting because these remind me of all the slips of paper that we collected during the nationwide constitutional consultation, which lasted 2 years. You know, people just scribbling down their thoughts on marriage law, whether or not there should be a national language, etc., etc. And boxes and boxes and boxes of those submissions are now housed at the Law Commission. So there was an interesting sort of comparison between the two things. Now, at the time that we've had our first chat, the situation, as many of you know, was getting increasingly parlous in Malawi, the political situation and the economic situation. In February 2011, I suppose this was the catalyst for a rapid worsening of the situation. Dr. Blessings Chinsinga, who is on the ARI advisory board and has co-authored a publication with us in the past, he was summoned for questioning by the Inspector General of Police for raising the question in a lecture of his at at Chancellor College, University of Malawi, as to whether the conditions in Malawi, with an overvalued currency that was leading to rapid inflation, foreign currency shortage, as to whether the conditions were in any way similar to those that had triggered the Arab Spring. Blessings was questioned. This was and released. This was the start, though, of rapidly rising tensions between the campus at Zomba and other campuses, and the government, and in particular the president. There was a standoff, and Blessings and 3 other academics were dismissed. Subsequently reinstated, but were at that time dismissed. Meanwhile, the economic crisis got worse. The price of tobacco collapsed during the year. Exports were running at well over twice the value of... imports were running at twice over the value of imports. Petrol was scarce and becoming increasingly expensive. And against this background, with an unwillingness on the part of the government to devalue the currency, the IMF suspended a crucial credit facility. President Mutharika suspended local elections until 2014 and began pushing through a number of laws which were unpopular and increased government powers and censorship powers. He also altered the national flag without public consultation, which the Constitution requires. I'd say we've got the right one because it's been changed back. So fortunately, we've got the right one flying today, I hope. Anyway, in July, yes, the representative from the High Commission is here, so now I can't see you. In July, riots broke out, and in a particularly tragic day, on July the 20th, 19 people were killed as a result of police action. Now, the protesters, through all of this, repeatedly, and to emphasise the importance of what we're talking about today, repeatedly asserted their rights and freedoms as enshrined in the Constitution, and repeatedly called upon the government through all this to reinstate the rule of law. So the law, the rule of law, and the Constitution were always very much to the fore throughout 2011-2012. So much so that in December 2011, the government referred a set of so-called bad laws back to the Law Commission for review. Now, this was a month after we'd been sitting here discussing this whole situation, and Janet was then involved or caught up in this process of having laws sent back to the Law Commission for review. This then was the backdrop for our collaboration. Hannah Gibson, who worked very closely as well from our end with Janet, flew out to Malawi just a fortnight before the late president died. Just days before she arrived, the Public Affairs Committee, an extremely influential interfaith organisation in Malawi, had publicly condemned government repression, as it had done in 1992, just prior to the end of the demise of the Banda regime. And it called on the president to seek a fresh mandate within 90 days or face widespread civil disobedience. I don't think when Hannah got on the plane we quite knew how serious the situation was getting, but we did get her back, so that was fortunate. In the PAC's 26-point communique, it expressed extreme disquiet that Malawi's predicament was the result of having a constitution without constitutionalism. So I'd just like us to have that as the sort of background for this piece. Now, clearly, a great deal has changed, but many things haven't since the now president, Joyce Banda, acceded to the presidency following President Mutharika's death. The constitutional review was essentially, or the recommendations and the associated bills submitted to Parliament as a result of the Law Commission's work were shelved in 2007. So we are in a state of suspension on that, and I know Janet will talk more about this. And it seems to me to be an extremely opportune time to at least try and move the dialogue forward, as far as there seems to me to be little point in having a full-blown constitutional review, a nationwide consultation and so forth, extreme expense in terms of time and money on the part of many people, and then to see the process shelved. But I would also add, before I shut up, that constitutional reform is only one aspect of law reform, and Janet will talk about law reform and its importance in a wider sense. Now, Janet will very kindly talk for 20-25 minutes. We hope that Malcolm will come and he will talk for 15 minutes or so, and then we very much welcome contributions from and questions from all of you on the floor. My apologies to Professor Thandika Makandawire if my brief summary of 2011-12 is lacking in many respects, but if any of you want it done precisely, speak to him afterwards. Janet, it is a great privilege for us to have you here, and it's been a great privilege for us to work with you on producing this publication. Thank you.
Thank you, Edward. It's always a challenge to give a presentation while seated when you're vertically challenged like me. So those who are like me know what I'm trying to say here. But I'll try my best. Let me start by saying that I'm most humbled to share my personal experiences in law reform with such a distinguished audience. I'm very grateful for your taking time to come and share my experiences, and I'm sure there will be a lot of exchange going on after the presentation. I also want to thank Edward, ARI, for giving me this opportunity to share my experiences and allowing me to share my experiences in such grand style. So I'm very thankful for that. And Hannah, for all the work that you have done. We have collaborated over the past months with your team. Thank you very much. I've worked for the Law Commission for 14 years. The Law Commission has been in existence for only 16 years. So the first 2 years of the Law Commission was really just to set up the institution. And it was at a time, as you know, the Constitution is a product, the Law Commission is a product of our 1994 Constitution. It was really established at a time when there was so much euphoria in Malawi. So as a young lawyer working for the Ministry of Justice at the time, I thought my future was in law reform and mostly to contribute to the development of the law in Malawi. That's why I crossed the bridge, because I started with the Minister of Justice. I remember when I went to the interview for the position of law reform officer, when I was asked the question, what law would you want to see change in Malawi if we give you this job? And my response, very prompt, and I was very enthusiastic at that time, was that the law on citizenship, because it treats women as minors, they cannot pass on citizenship to children or to their husbands. And then the other area that I mentioned at that time was the age of marriage in Malawi, because I could just imagine my daughter at 15 getting married. For me, that was unthinkable. So those were the areas that I identified at the time, and when I was taken for the job, the first report that came out of the Law Commission, Law on Citizenship, Marriage, and it went to Cabinet. Boy, did I get the shock of my life. Cabinet that time was full of men. I think there were only 2 ministers. The rest were men. So what they did was to say that you cannot change the law on citizenship. It doesn't matter what the Constitution says, because it will pose a threat to national security. We don't want women to bring in undesirable elements into our country. That was the reasoning. And then on marriage, the reason given was that culture. We as men want to protect our girl children. We don't want them to end up misbehaving. They are better off marrying at that young age. So this is really for their protection and benefit. So what was the lesson that I got from that? The major lesson was that when law reform encounters male chauvinism, there's no hope for change. It doesn't matter what the Constitution says. So that was how I started my law reform work with the Malawi Law Commission. Now, in terms of my presentation, I think I've divided it into 6 categories. I'll start by talking briefly about the Constitution, basically just to put issues into context and highlight the standard of care that is required of those exercising state authority in Malawi. And then I'll move on to the 3 arms of government, the executive, legislature, and judiciary, mainly because I consider them as agents of law reform, to give the context within which the Malawi Law Commission operates. Then I'll move on to the Law Commission itself in terms of the mandate, work methodology, funding arrangements, and generally the opportunities and challenges that are encountered by the Law Commission in Malawi. And then I'll talk about the constitutional reform program, because it's one of the major programs that the Law Commission has carried out so far, and one of the successful, as long as we are concerned, because we did our best. And then I think I will just conclude by generally talking about the importance of law reform in young democracies, based on the experiences that we've had in Malawi. As you can see, the title of the presentation of the publication is Duty of Care. For those of you who are lawyers, know that expression is normally used in tort law, not constitutional law, mostly. And in tort law, it's really talking about the legal obligation that is placed on individuals, the requirement to adhere to a standard of reasonable care, especially when performing acts that may be foreseeable, that may cause foreseeable harm to others. But I use the same term in the sense of constitutional law and constitutionalism in Malawi. For me, duty of care for Malawi, I think I've interpreted it to mean that it's a legal obligation imposed on those exercising state power, requiring that they adhere to constitutional principles while exercising such power. Malawi adopted a constitution in 1994. It is a very elaborate document. It introduces the doctrine of separation of powers, it incorporates a Bill of Rights, it introduces new constitutional bodies, state institutions. But my favorite chapter in that constitution is chapter 3, because that chapter deals with provides actually the fundamental principles upon which the Constitution is founded. So for me, I can ignore the rest of the Constitution, but Chapter 3 is the thing, the bedrock of our Constitution in Malawi. One, it imposes the standard of care, as I mentioned, required of those exercising state power, and then actually lists down the principles upon which our Constitution is founded. And the fundamental principles in our Constitution are divided into two categories. We have what are called constitutional principles, and then we have what are called principles of national policy. But for the sake of the presentation and for the sake of law reform, I focused on the constitutional principles. For one, as I mentioned, they provide the bedrock, but also, as far as I'm concerned, they provide, actually they advance superior principles compared to the rest of the principles scattered all over the Constitution. In a sense, they set the standard of care, the duty of care that the executive arm of government, the judiciary, the legislature should adhere to in performing their mandate. In summary, the constitutional principles are as follows. One, state power comes from the people and is to be exercised and applied solely to save and protect the interests of the people of Malawi. Two, exercise of state power is on people's trust and in trust for them. This is very important, and you'll see later as I go into my discussion. Should be exercised to the extent of such authority. Three, the exercise of state power is conditioned upon the sustained trust of the people, maintained through an open, accountable, and democratic government. Four, the exercise of state power must recognize and respect dignity and worth of every human being. You will see that these are the principles that I've just read out are really to do with good governance and protection of human rights, the dignity of individuals. And then the last two, one is all people have equal status before the law, so equality before the law. And then no person or institution is above the law, advocating for observance of the rule of law. So the principles of the constitutional principles that form the bedrock of the Constitution of Malawi promotes good governance, rule of law, and rule of law, observance of the rule of law for the state institutions. And I think I was able, for me, I'm able to take out two significant characteristics from these principles. The first one, they actually bring out the democratic character of our Constitution by spreading the standard of governance required back to the issue of duty of care. And then secondly, they place people at the center as beneficiaries of state authority, which is a fact that is most of the times forgotten in young democracies. So all the state organs are required to adhere to these standards. Now, how do the executive, the judiciary, or the legislature operate bearing in mind the duty of care that has been imposed on them by the Constitution? I'm going to discuss this in terms of their mandate, and I think just relating to what has been happening to Malawi as well, to bring in the practical experiences. When I look at the executive and what it has been mandated to do, which everybody knows, that it's normally executive arms of government are supposed to initiate policies, initiate legislation, implement laws. The executive in Malawi, as far as I'm concerned, has fallen short of living up to the duty of care that has been imposed by the Constitution. Because the Constitution specifically requires the executive to ensure that when coming up with policies or legislation, the policies should embody the express wishes of the people of Malawi. But what has happened is that the executive, I think...
Oh, I'm sorry.
Okay. Yeah.
Sorry to interrupt.
No, it's
Absolute pleasure. Thank you very much. We've introduced Malcolm. Janet,
Yeah.
you may.
Yeah. The executive in Malawi for the past few years has been obsessed with initiating money bills. And money bills in the sense of just facilitating revenue collection and also facilitating access to bilateral and multilateral loans. I looked at the legislation, the statutes that were passed like last year. All in all, it was like 26 pieces of legislation and 16 money bills. And you look at the rest, at least they had 4 bills from the Law Commission, but the rest, you couldn't even place them in terms of forming an opinion about the legislative agenda of the executive arm of government in Malawi. In terms of the legislature, they're supposed to enact laws. They're the biggest agent of law reform. And in enacting laws, they're supposed to ensure that their deliberations reflect the interests of the people of Malawi. And in addition to that, they've been given an additional responsibility of creating a constitutional order in Malawi. So the burden of making sure that Malawi is a constitutional state and constitutionalism is promoted has been given to the legislature in Malawi. But what has happened? A lot of factors have weakened the legislature. I think I've categorized them into 2 and termed them crippling factors. The internal factors, which are really largely influenced by self-serving amendments to the Constitution. Amendments such as the removal of a recall provision. We had a provision, Section 64, which allowed your constituent members to recall a member of parliament if they are not performing. So that provision was repealed. The Senate, as an upper chamber of parliament, was also repealed, and these all were self-serving amendments to ensure that the members of parliament were not accountable to anybody, not to the people, not to the upper chamber of the House. And then there also have been developed what I call self-serving practices in the legislature, which has seen members crossing the floor willy-nilly. Today, I'm a member of, for example, we have UDF. Tomorrow, I'll be PP. The other day, I'll be MCP. And yet, we have a law that prohibits that, Section 65, but nobody is paying attention to it. External factors that have also weakened the institution of parliament in their mandate is what this I think this is, somebody may challenge this, but it's an opinion. The judiciary sanctioning of Section 94. That section prohibits the president from appointing members of parliament into cabinet on the basis that they are public officers. But what has happened is that the judiciary, in their wisdom and for political expedience, have interpreted the provision to exclude politicians. So if you are in political office, for example, if you are a member of parliament, you are a president, you are a cabinet, you are not in public office. You are just in political office, whatever that means. So that is the situation in Malawi at the moment, and it has contributed a lot to the weakening of parliament, because now the president gets all his ministers from parliament. So you can imagine what has happened in terms of separation of powers and checks and balances. You cannot have effective checks and balances in a situation where people are busy positioning themselves to get cabinet posts. So what has been the result for parliament? It's not accountable to the people, it's very weak. It's not even in a position to carry out its legislative mandate. Even when you talk about private members' bills, parliamentarians empowered to initiate private members' bills. I just took stock and saw that since we got the new constitution in 1994, only 4 private members' bills have been initiated by Parliament, and this is like more than 18 years down the line. And also, you see that the private members' bills that were initiated were for political expedience. For example, there was a bill to prohibit the putting of faces on to amend the Reserve Bank of Malawi to prohibit the putting of faces on the face of the on the face of the money, so that the money should bear neutral features. And then there was about the presidential terms, and then the other one was crossing the floor. But it's all to do with politics. Nothing about thinking about the people who have put you in power, and nothing about exercising your authority in regard to the people who have put you there. And when it comes to the judiciary, we know the judiciary is there to interpret, protect, and enforce the constitution. And the duty of care that has been imposed on them is that they need to do this in an impartial and independent manner, and also recognize that the constitution is the supreme arbiter and ultimate source of authority. But we have instances where High Court judgments have been overturned for political expedience. I've already alluded to one example about allowing MPs into cabinet, despite what the constitution says. The other one, the press trust, where the constitution prohibits arbitrary deprivation of private property, but it was decided for political expedience to allow the deprivation of private property. So you can actually see that the balance that was supposed to be there, the balance that the constitution tried to put in place in terms of the 3 arms of government has been distorted. And then where does the Law Commission come in all this? The Law Commission is an organ of the executive arm of government. It's an independent institution established by the Constitution, and it's headed by a law commissioner for a renewable term of 5 years, somehow to secure the tenure of the head of the institution. And as I indicated, it has been in existence for 16 years. It has worked with the Muluza administration, the Bingwa Mtalika administration. Now we have the Joyce Banda administration. The mandate of the Law Commission is to review the Constitution itself for inconsistencies and also the laws of Malawi in line with the aspirations of the people, but also to align them with applicable international human rights instruments. The Law Commission is also mandated to harmonize the laws, codify customary law, all this in a bid to ensure a systematic development of the law in Malawi. And how does the Law Commission work? It receives submissions. Different from the other law commissions, where sometimes they get submissions only from maybe the Ministry of Justice or the executive arm of government. In Malawi, the Law Commission receives submissions from everybody. It can be government, it can be civil society, individuals, or private sector. And this has worked to our advantage because we've seen that it has helped in building trust for the people. It opens up a window where people can come in and just say, can you please look at this law? And that is a plus for us. It means we are very accessible. And then it also has removed the perception that legislative reforms or law drafting is the preserve of the bureaucrats are somewhere in Capitol Hill. We work with them from the grassroots. But there is a disadvantage. The disadvantage is that as an institution, we are inundated with submissions. So we really have to exercise our discretion very carefully in terms of prioritizing our work, because everybody is like looking at us, trying to see what we are going to do. We are always having programs that we cannot handle at one particular, during one particular financial year. So what guiding factors do we use in deciding what law reform to take forward? Normally we look at inconsistencies, especially with the Constitution. If we feel that the law is so departed from what our Constitution says, we give it priority. Obsolescence, but we also look at government priorities. The Commission itself can also instigate reforms. Normally you don't just wake up. These come from the other programs that we're doing. You find that there's a law that needs to be looked at because of what you're doing to the other law. So I think in the interest of harmonization, sometimes we can instigate our own law reform programs. The methodology that we use as a commission is highly consultative and very expensive. We have the disadvantage that we are not technologically advanced, because I know that in our sister institutions in developing countries, they rely so much on the internet. In our setup, that is not effective. You really have to reach out to the people. So you have to go to the grassroots. Normally we use district commissioners in the rural areas. We organize roundtable discussions, workshops, and use the electronic media a lot, radio programs, phone-in programs, panel discussions, all in the interest of, expanding outreach and ensuring that the laws that we are moving forward or we are pushing forward reflect the wishes of the people. So it's in that context that we carried out the Constitutional Review Program. That program started in 2004. That time we had just moved to the Third Republic of Bingwa Mutharika. So it was an opportunity, a window, and it was very receptive. I think the environment at that time was very receptive, and we thought it was ripe for constitutional review. The submissions did not come initially from government. It was really from the people, from civil society, from political parties. So I think we went on a consultation program throughout the country, but we also engaged the then Minister of Justice. Of course, there was reluctance at the first because normally constitutional reforms are not light business, and also the outcomes, the proposals might not really be in the interest of the incumbent government. So there was a little bit of resistance in the beginning, but then I think along the way they were taken on board and they were very enthusiastic about it. So we started with consultations and compiled a report that was presented to the what we called the first Constitutional Conference, National Constitutional Conference. We had that time an international consultant to give an international perspective from UK, and then we had a regional consultant, and then we had our local people as well. After that, I should mention that the first National Constitutional Conference was actually graced by the head of state. So there was a lot of political will at the time, and we were so hopeful that the reforms would be taken forward. After the Constitutional Conference, we empaneled a special law commission. The commission worked for a period of a year. The consultations took 2 years, almost. And then the commission worked for a year and compiled their report, draft report, which was now presented to the second National Constitutional Conference. That one was graced by the Chief Justice, and we're still in very high hopes that things were moving the way they should be moving, and we're also informing the executive arm in terms of the reforms that were coming forward during that period. And after the second National Constitutional Conference, the report was finalized and submitted to the Ministry of Justice. But among the issues that were contentious at the time, there was the issue of death penalty. We had the issue of national language, whether we should have a national language in the Constitution because as an official language, because at the moment in Malawi it's English, and people are like, come on, this is how many years after colonization and we are still talking about English as the official language. And there was the issue of age of marriage. And not only that, there was also the issue of the definition of marriage. So in our Constitution, marriage is man and wife, man and woman. So I think there were proposals, submissions that we should change that. Constitution should not dictate. So those were some of the contentious issues that came up. So we had our report, we made our recommendations. I think some of them have been highlighted in the publication. I'm not going into what we recommended in the interest of time. But after all this, what are the lessons and challenges that I have learned working as a law reformer? The first is that the rate of adoption for law commission reports is very low. And for us, we had a very huge program, Access to Justice, with a component on criminal justice reforms that has suffered the worst blunt of government delays. For example, we reviewed the Penal Code in 2000. It was only enacted, passed into law in 2011. That was 11 years after the fact. The criminal procedure, it was the same thing. I'm highlighting this because the Law Commission is supposed to promote systematic development of the law. But if you have sporadic adoption of reports, it's not possible to fulfill your mandate as an institution. And we also learned that the source or origin of a submission also determines whether it's going to pass through very quickly or not. So if you have submissions from, and not only just from government, but from the Minister of Justice, you are assured that within 2 years, that will go through. Because we've had a program that I think that only took 3 months, and the next day you have a law. So the time frames when I was looking is like 3 to 2 years if the submission is from Minister of Justice. From the other government departments, they have to wait the queue. From civil society, forget it. So the other thing is the level of public interest also determines if the proposals from the Law Commission are going to be taken on board. But we've learned that for the constitutional review, it hasn't been the case, though it generated a lot of public interest in the country. Up to now, the report is still there, waiting to be attended to, gathering dust somewhere. And I've also attributed the lack of enthusiasm to adopt reports to Parliament's neglect of its own responsibility. Because if Parliament was able to push the executive, maybe things would move. But the thing is that we just discovered that even in Parliament, though the law requires that when you're doing your reports, when you're submitting the report to the Minister of Justice, the other one should go to Parliament direct so that the Minister of Justice can lay the report in Parliament. That hasn't happened in the past 5 years. And when I tried to find out, I was able to learn that the office of the COP just kept the reports in the library. So you have a Parliament, for example, for about 298 people, and you print 290 something or 300 reports. That is already an expense, and you give them to Parliament so that they can read and also anticipate the reforms that are going to be submitted by the executive to Parliament. And then you have an office that is just keeping the reports in the library, gathering dust. Very frustrating. Though there's that bit of grim picture about law reform, it has got its pluses. That is where I'm going to conclude. For the constitutional review and this publication, the idea is that it should resurrect the debate over constitutional reforms in Malawi, because a lot of work and effort and expense went into that exercise. It is hoped that if those proposals are taken on board, at least it can redress the imbalances that have been created over time, over the period of time, with the self-saving amendments made to the Constitution, and also maybe correct some of the errors maybe encountered by the speedy manner with which the Constitution in Malawi was adopted in 1994. So, do we need the Law Commission in Malawi? Is law reform important for a young democracy like Malawi? Is it making an impact? I think the answer, despite the downsides, there are pluses for law reform in Malawi. it attempts, I will not say it promotes, I will say it attempts to promote the systematic development of the law, especially when you consider that the judiciary, the executive, and the legislature, in carrying out their functions, are wanting to some extent. They're agents of law reform, but they're not carrying the law reform agenda forward. So it's up to the Law Commission to try to fill the gap. And somehow, somewhere, somebody will listen to the voice and take up the reforms. So it's really a hope. I also consider that the Law Commission, or the law reform in an institutionalized manner, the way it is in Malawi, is important because it also promotes popular participation in legislative reforms, and it encourages ownership of outcomes by the people. We have an example of the Local Courts Act, which civil society, I think, because it's very reactive, wanted to shut down, but the people are saying, no, we want this because we were involved in this. And also, it also ensures, law reform ensures that proposals for legislative reforms, as I've, I think, been indicating throughout, embody the express wish of the people of Malawi, and provides a credible tool for legislative reforms, especially in this era where people are very suspicious of the motives of their governments as far as legislative reforms are concerned. My experience has shown that since law reform is a byproduct of a liberal democratic constitution in Malawi, the expectations are too high for the institution. It is expected to address the legal aspects of social problems. The Law Commission is also expected to reform all the autocratic laws, and people want you to do that as of yesterday. And they also want you to promote awareness of the laws and the status, tell them what the law says. So that is a huge responsibility for the institution. But it also shows that people really want the Law Commission or law reform to stay put the way it has been established in Malawi. I thank you.
Thank you very much indeed, Janet, for an extremely balanced assessment of what has been achieved and of the challenges facing law reformers in the country, and indeed for expressing the hopes of law reformers as well. I slipped a note to Malcolm saying I've introduced you, but the poor man, of course, doesn't know what I've said, so I won't repeat the whole caboodle. But I would just like to say that to repeat within your earshot that your presence is especially welcome today and relevant because of the close ties between the Scottish Law Commission and the Malawi Law Commission, and indeed between the justice sectors in the two countries. And we know that the Scottish Law Commission has also got close ties with the Uganda Law Commission and others in sub-Saharan Africa. So you've achieved the remarkable in getting to us, in defeating what the airports and airlines have thrown at you, and you are most welcome. Thank you very much.
Thank you very much. First, my sincere apologies for arriving late and interrupting your fascinating presentation. I did spend a few hours in the mist in Edinburgh Airport, and shortly I'll be returning, I think, to the mist again. But it's an honour to be here. Thank you for inviting me. And first of all, congratulations to Janet for a fascinating, excellent publication which is produced today, and also to Edward and the Institute for helping to promote law reform. And for those of us who have a passion for law reform and see the strategic value to any country of law reform, this is a very important occasion and a welcome contribution. So thank you. I think I'm here, how to explain myself, from what am I doing here from the bleak north to speak about sunny Malawi. I think time is pressing, I would guess, so I think I'll try and pick out bits of what I was going to say. But to explain, first of all, a little about the links between the Malawi Law Commission and the Scottish Law Commission. As you might know, there are long-standing links between Scotland and Malawi, and that went back to the days of the missionary activities, Dr. David Livingstone. And these links were through the churches, education and health. And we're going to hear a lot more about that next year with the 200 years celebrations since the birth of Dr. Livingstone. with that background, we had devolution of power in Scotland in 1999, a new parliament, a new administration, and the new government, led by now Lord McConnell, wanted to have a place in the world and play a role in international development. And what better than to concentrate on the historic links that we all already had between our two countries. So that led to an intergovernmental agreement signed in 2005 between Malawi and Scotland, in which there'd be cooperation and assistance in health and education, and now new things have been announced, for example, in renewable energy, in which Scotland has a kind of international expertise and was asked by the United Nations to share it. But a couple of years ago, the government agreement moved into the area of justice, and that's where we can come in. And there are quite a number of links now under this programme, Capacity Building for Justice, between justice institutions in Scotland and Malawi, all with a view to sharing, encouraging. It's not about money. This is Scotland, there is no money. We are a small devolved region, but it is about links and the continuity of links between partner bodies and sharing knowledge, sharing skills. And in that context, the Scottish Law Commission and the Malawi Law Commission formed a link a couple of years ago. Now, so we're terribly interested in everything that's happening in Malawi and very interested to support anything in any way we can. How do you keep a long-distance relationship like that going? Well, it's a bit like trying to keep a long-distance romantic relationship. It's not easy. You meet occasionally, but there are things you can do, and it's an important part of our work. So that explains the link between our two commissions. And of course, we have shared objectives and shared concerns. So we're both independent law reform bodies. We both advise government, and that means we both, as Janet said, have got an interest in seeing our recommendations implemented. So maybe, as Edward has asked, I could tell you just a few things about the Scottish experience of trying to address the shared disappointment of law reformers and the lack of implementation. Because that's where we certainly were in Scotland. Before devolution, actually there's a very good rate of implementation of law reform for Scotland in the UK Parliament. Very good, both for our joint reports working with the Law Commission of England and Wales, and also for our Scottish-only reports. And you'd think that come devolution with your own Parliament in your own country, that things would be absolutely wonderful and all sorts of technical law reform measures would be introduced. But that actually didn't happen to our surprise, and the rate of implementation of our own reports plummeted over the years since 1999. What were we going to do about it? And perhaps that's something of use that I can try and share today. First of all, I suppose we noted it as a serious issue and decided to tackle it in a strategic way, raising it as an issue of public debate and using the media. So this we did by way of our chairman's forward on our annual report, and releasing a press notice to the press and the media and the public. And that got a lot of attention because I'm afraid it was against the government, and that immediately is an area of controversy. So that was excellent. I got a number of interviews, a lot of press reports, and the Scottish Government replied saying we value the work of the Commission and value the law reform thing. So after that we moved into a kind of back to a warm, friendly relationship with ministers and government. And the fuss we created sparked off a number of meetings with ministers, Cabinet Secretary for Justice, Minister for Parliamentary Business, on to officials and Director of Justice. And there were results from that. Ministers agreed with the merits of what we're saying. They agreed it's a waste of all the efforts of consultees, a waste of all the efforts of a law reform body or thinking, and maybe 3 years' work to produce a report. So that led to a number of activities. Government officials began looking at our old reports to see what could be implemented and to start government consultations in some of these. We got agreement to look at the Scottish Parliament to see if there's problems in getting bills through. Is there logjam? Are there problems there? So these were our two routes, Parliament and government. And in looking at what could be done, we did have regard to what other people do in other countries. England and Wales is a particular example. Plagiarism is not a dirty word in law reform. It's actually a legitimate tool of law reform because you're looking at what other people do. If someone has got a solution, why not follow it? And it's a complement to the host jurisdiction. So we did look at what other people had done in our strategies. But in fact, at the end of the day, what had been done recently due to Law Commission for England and Wales, similar concerns, is that statutory duties were put on the Lord Chancellor to make an annual report to the UK Parliament on implementation of law reform recommendations. And secondly, there's provision for a working protocol between government and Law Commission. And then the day, our own Cabinet Secretary in Scotland decided not to follow that route because Scotland is much smaller, everything happens on a smaller scale. So what we have is a series of administrative arrangements, agreements with government in principle, which have been published and which we hope are helping us. One is, for example, the Cabinet Secretary has agreed to make a public response to the submission of each of our reports. That's published, it goes on our website, and that can be raised in Parliament by a parliamentarian. We can raise it, journalists can raise it. It's a method of holding government to account. What we want from the government is a kind of discussion. What do they think of our recommendations? What are their plans to implement it or not? So it's another step in discussion. And secondly, we engage a lot more with the Justice Directorate in our country, both generally on progress with what we're doing and our planning of business, but also on individual projects to try and soften up and lift the awareness within government of what is coming. So a report after 5 years' work, 2 years' work, doesn't just land on an official's desk as a complete surprise. So they're aware of it, they can brief the Minister of it because they know what's coming and know the rough shape. One of the questions is where's the independence of a law reform body in the midst of this? And I think it's all right. I think what we're talking about is business planning really with government and Parliament. I don't think we're compromising the independence of the law reform body. We're very jealous of that. And I think the essence of the independence and therefore the utility of what we're doing to the country, what we're offering, is the independence of our recommendations for changing the law. So that's the way we see it, and that's the way we've developed relations. To touch just a few more minutes.
Sure, absolutely.
To touch on to touch on the other important component of the strategy is what we're doing with the Scottish Parliament. What we wanted to do is raise law reform as an important issue with the Parliament, to get them to embrace the idea that they are the legislators, they are the ones making laws in Scotland, they have a responsibility to bring the law up to date, to keep it modern, to make Scotland a place to do business efficiently, to encourage employment, etc. Because I think maybe that perhaps had been lacking. So what better way to do it than offer them hospitality, wine, receptions. So that's what we did. We went to the Parliament at Holyrood. We held a number of seminars with hospitality, but in particular with all our commissioners there, and a presentation on law reform and on each of our law reform projects and how they'd fit in to the general objectives for Scotland. The government has some objectives such as a fairer Scotland, a wealthier Scotland, a greener Scotland. And we're trying to align each of the pieces of work we're doing in towards these ultimate objectives to show people how we fit into the whole machinery and that we are offering something of value. So the end result of engagement with the Parliament is we're looking at different ways to stop the logjam of law reform bills in the Parliament. We looked at creating could the Parliament create a second Justice Committee, which has the heaviest business of work? Could we maybe create a new committee? And we ran into problems, the very slim majority of the government in Scotland, so they're not always confident of getting enough committees together on which they'd have a majority. So the end result is we have had a working group of officials. It has reported to government. Government has accepted it. The recommendations are not in the public domain, but they're now with the Parliament. And I can say from the Law Commission's point of view, we're hoping there will be a new procedure in the Scottish Parliament for law reform bills, maybe enhancing the role of one particular committee so that we'll do technical law reform bills. And our hope is we'll give them a pilot, small, very small, easy bill on that technical law reform, and hope that's a success, and then feed them one or two further bills, and that will evolve into a proper law reform procedure. We've been able to point to precedent. The House of Lords have a special procedure for law reform bills now, which has been magnificent. It's helped the Law Commission of England and Wales, and last week our first Scottish-only Commission bill was introduced into the House of Lords using that particular procedure. So, my last thing is a warning. There's a quid pro quo and all that, which is, well, we're wanting the government and the Parliament to do things for Scotland, do more law reform. The government are looking to us, the law reform body, to do more work. In other words, to start preparing a lot of the documents, the standing orders of Parliament require, policy memorandum for the bill, financial memorandum, preparation of impact assessments. So that's all fallen to us to do, and that's, I think, the quid pro quo. So I'll stop there. I hope these comments are of interest, and I very much support the calls for greater implementation of law reform in Malawi.
Thank you very much indeed, Malcolm. I think what's very striking is how similar many of the obstacles are to law reform. In two completely different countries. Malcolm, you've actually got an additional obstacle, haven't you? Because you have to deal with two governments, I would have thought, instead of one.
The constitutional settlement has not helped us. The Scots law is split. Some of it's reserved to Westminster Parliament and some of it's Scotland. So yes, we have two battles.
Two battles to fight. I hope that in the course, I want to throw the discussion open as soon as possible, and I hope that perhaps somebody from one of the law reform bodies represented here today could talk about the opportunities, greater opportunities for cooperation between international, between law reform bodies in different countries, and I hope also that Malcolm's very kindly cut his presentation short, but I hope that he will have the opportunity to talk more about what they have learnt from Malawi and what they've been able to help the Malawi Law Commission with. I know we are running a little late. I know some of you will have to go, and please do so when you need to. But I now welcome suggestions, questions from the floor. Do try and keep them reasonably brief, please, and we'll keep going for as long as the questions and suggestions come, and for as long as Janet and Malcolm have the strength to carry on. So over to you, please. Yes. Could you just say your name and an affiliation before asking questions? That would be very helpful for us.
I'm Sam Buscemi, and I support local street markets of London, and I blog about sustainable street markets and run walks around them. My question is this: when did women get the vote in Malawi? That's one of my questions. I want you to ask that. And then following on from when women got the vote, how one can deal with the inherent sexism that you describe, which has a legal net of its own as regards equal rights for women in terms of the destiny and their marital choices, etc. For instance, do Malawi men have the right to bring in people from elsewhere, with wives or whatever from elsewhere. It's just that women cannot bring in husbands.
Thank you. Should we take another couple at the same time? Yes. Edward.
I wanted to ask a question about the faiths in the process of law reform in Malawi. To ask really whether they were influential, whether they acted together in a united way or in a disunited way on bits of the constitution, and which particular parts they were most concerned about.
Thank you. Yes, sir. Sorry.
Thank you. Well, my name is Nelio, and I've been working in Africa since 1987 with the African Development Bank, and now I'm a consultant again after retiring. And so in order to put my question, I have to say just 1 minute, what I think about, what's happening in Africa now. I think the main problem in Africa is when I joined the ADB, African Development Bank, was the year that, all these international reforms start to be made in Africa. See. So since then we have the implosion of the state. Every state, started by Somalia, and eventually we had, Cote d'Ivoire, I think was a very good state, very organized. Anyway, so I don't know how you can implement all the reform if you don't have a functioning state. So my question to you is, does Malawi the state has got the resource, human and financial, to implement this reform? If not, what should be done? That's my question.
Thank you. Thank you. Janet, would you like to start?
Yeah, I think I will start with the last question. I think Malawi, we cannot really categorize it as a, what was the expression you used, failing state?
The implosion.
Implosion, you
of
said.
the
Yeah.
state.
And were you talking about post-structural adjustment?
Yes,
From then on? Okay, fine. To set the
As
context.
has been working
Right.
a lot of, institutional reform now for 20 years, and I don't see any results at all. Anyway, so I think when you cut off, all the revenue, because the point is that state was considered that big state in Africa was the main problem for development, for private development. So let's have a small state. So resources were accounted for education, for health, for everything, and even the state itself. So the state could not function. Anyway, so there was no middle class. So the only things that functioned in Africa, was the state. When you cut the state, you debase the state. So what I call implosion, because it's from inside. So the state has no way to function. So it's like a boat without a captain.
Yeah, I think all I can say to that question is that reform, I think in Africa in general, is really dependent on the political will.
Yeah.
So if there's no political will, you cannot hope for much, regardless of the other factors that you're bringing in. It's really dependent on the political will. So like for us in Malawi, because of the distortion that has happened, it's like we have a very powerful presidency. So it boils down to the benevolence of the person who is in that office. So that would be my quick answer to that question. I don't know if it has responded, because I know that I cannot give you the answer that you want to hear. That is a common answer that people give. It's political will.
Can I add? Resources are critical here too.
Yeah.
You said the very interesting thing. It is expensive to do law reform, so somebody has to provide this. And the law reform, you started out with 2 people and the typewriter, as it were, and now there is a dozen. There is room for so much more to be done, and this resource has to come from somewhere. It either outside, or there has to be a political decision to make the resources available internally.
And I think for us, when you look at the programs that we have carried, I think I was just taking stock. We've done like 23 programs. Only 3 of those have been supported by government. It's you're really depending on development partners, which is not a good thing, because at the end of the day, you end up towing the agenda of the donors rather than the agenda of your own people. So that is a challenge.
That's improved, though, hasn't it, for you in your case?
Improvement. The improvement in the sense that from the 2004, when we started the constitutional reforms, that's when government came in, but it just co-sponsored. But at least it was a start for us. So at least 3 programs are now funding we're reviewing the law on witchcraft. They co-sponsored the constitutional reform. We are hoping that they will continue in the future to sponsor. But most of the programs have been sponsored by, I think, development partners. Not that government cannot sponsor them. I'll go back to the issue of political will. If they can sponsor 1 program, they can sponsor 2, they can sponsor 3. Right now, the focus has been on personal emoluments and other recurrent expenditures. But for all reform programs, the funding hasn't been forthcoming too much, if I can put it that way. I think there was the other question about the process. Was it the process of the constitutional reform or the law reform and the parts that people were in agreement?
Faiths in particular.
Well, I wonder.
I thought it was that was.
It was
faiths in particular, wasn't it, Edward? Sorry.
Yes, I apologise. I should have said I'm Edward Clay, and I used to be a British diplomat. And my question was about faiths and the influence which they had or have in the law reform process, and whether they work in a united way, and which particular areas of reform they are most concerned about.
faith and religion, interdenomination.
Yes, exactly.
Okay.
Yeah.
We've been working a lot with PAC. PAC is a public appointments committee, and the faith, the interdenomination, I think representatives are in that grouping, and it's a very powerful grouping in Malawi, and they exert a lot of influence. Obviously, they would be interested, in terms of the areas, they would be interested to know what the Law Commission thinks about what a marriage should be, the issues about death penalty, issues of age of marriage. So those are the areas they were very keen to hear about the proposals that we were making. And they were very united, whether Muslim or Christian. But in terms of handling the issues, I think the only point of departure was to do the age of marriage, where the Muslims, I think, felt that 15 was okay because they can marry earlier. But in the other areas, they were so united in terms of their proposals. Yeah.
I think it's very the PAC is actually in the newspapers today, because they've very publicly made their first statement to President Banda since her accession, and a number of the things that they raise in very clear language are things that Janet has written about in her publication. Section 65, for example, the whole issue of crossing the floor, and the recall provision as to whether and those are things that the PAC is calling upon the government to address. So that is in a totally united way as an interfaith organisation. So it's a very topical question. Thank you.
Yeah, the other question was about when did women in Malawi get the vote? It has always been there. Women have always been allowed to vote in Malawi. I don't know since when, but it hasn't been an issue in Malawi, because I think we just copied whatever laws we inherited and made them into our own. So I think by that time, women in the UK were already voting, so it hasn't been an issue in Malawi. But in terms of going about solving the problem of discrimination, I think what we do as a law commission, because we have this ancillary function of carrying out civic education on the status of the laws. So we target, most of the times we target parliamentarians, civil society. If they can make noise on our behalf, we are happy. We've tried to approach members of cabinet, not very easy. For the constitutional review, it was possible to sit them around the table because it was a program of national interest. But the others, they will not show up. But parliamentarians, at least we try. And we
How
always,
many women in your parliament then?
at the moment, there are about 40
Out
out
of
of
193.
193, yeah, out of
196.
3.
193, and then 40 women.
Yeah,
Yeah.
about it.
And are you related to President Banda?
No, I'm not. Banda is a very common name with Malawi.
Thank you. Yes. Yes, sir.
Yeah, my name is Nico from the way of London School of Economics. just 2 points. One big point actually related to what you call political will and constitutionalism. I think, if I may say something positive about Dr. Banda, it's quite rare, that he left us a very interesting a legacy, which had 3 elements. One was that he never used the judiciary for political repression. He used traditional courts. So the judiciary was left out of the politics in a sense. He didn't use the army for repression. He used young pioneers. And the civil service was fairly meritocratic. And that's quite unusual. In many countries in Africa, when you move to democracy, you have a judiciary heavily tainted from, and the military is compromised and so forth. And so we didn't have that. And so there's a basic trust in Malawi of judiciary. As you can see from the number of endless litigation, we all go to court and people sort of accept the ruling of the court. When I say just compare with Kenya, that's a big advantage. Now on the downside, politically Banda left us a culture of sycophancy, of impunity, and basically a lack of respect of law by those in power. And I think that's very strong in Malawi. And that's what we consider perhaps according to political will. In fact, we do have a political culture, where the heads of state think they can actually ride roughshod over the other. On the promising side, I think, at least from what I see here, one has been a remarkable activism of young lawyers in Malawi. I mean, they're really quite remarkable in terms of challenging the state of law and using law. And also there's been, I think, the churches also, they do about the law. And I've seen some of the surveys done by, opinion surveys done by Afrobarometer. And Malawi's come up very high on their rights, very strongly about their rights. And of course, given our history, maybe it makes sense. So I think if you combine the positive elements of the legacy of Banda and this activism, we should be able to at least overcome the bad side. And if you keep it up as you're doing, it's very good.
Thank you very much. Yes, sir. Oh, I'm sorry.
I'm Dr. Caesar Chai. Ugandan-trained doctor at Leeds, work from the UK. First point, question really to Dr. Malcolm Macmillan. You raised the issue of impact assessment. And I want you to talk a little bit more about that, because I think there is some learning there for Africans to impact assess before actually launching into something. And I mentioned also because we have a lot of what I call parochial laws sometimes, making their ways into parliament. For example, in Uganda, what's going to parliament now is the anti-gay law, which is really not a big issue, but it's grabbed such a big headline, And so I want to talk a little bit more about the impact assessment at the stage when law reforms are being put forward.
Thank you. I'm sorry.
Thank you very much. First of all, let me thank Janet for her introduction to the paper, which I'm looking forward to reading, and for sharing your thoughts as to the whole subject of law reform in Malawi. I think before I ask the question, I just wanted to make, I'm Jarvis Mati from the Commonwealth Secretariat. I just want to make a comment with regard to law reform, and to say that law reform is an essential element of the rule of law work of the Secretariat. We find value in sharing experiences and ideas amongst many of our countries, most of whom are small states and in need of law reform. So I'm just saying this in response to your question in terms of how we can move this forward. In terms of what we're doing at the moment, we're working with Commonwealth Association of Law Reform to look at what are some of the best practices that are coming out. You talked about challenges, Janet, that you're facing in your work and how you want to move forward. We want to identify those best practices and put them together so that some countries can look at those and learn from them and see how they can improve on their law reform programs that they do have. The question I have for Janet is that you mentioned, you talked about a lot of work that you have done, but a lot of work which has not come to the end in terms of the programs that you have implemented. In your assessment since law reform was introduced in Malawi after one-party state, what are the main areas that have been ignored, the main recommendations that have been ignored, and what is the strategy that the Law Reform Commission is taking to deal with that kind of situation? Because I think it must be very frustrating to put in a lot of work and to see that work doesn't come to fruition.
Thank you very much. Would you like to start there?
I'll start with the last with Jarvis. Many areas that have been ignored, I don't know if you have given thought to that, but what I know is that government adoption of law commission reports has been sporadic. There's no pattern at all that you can say that they don't like these laws, they want these laws. We have a huge program on economic laws. It's just sitting there. We cannot understand why when you're talking about investors and the like. And then we have a huge program on gender-related law reforms. Some have gone, some are still waiting. Reforms on marriage and divorce, child rights and whatever. And then we have criminal justice, I've already alluded to. There's no pattern. I think it just is at the whim of the person who is holding the office of the Minister of Justice at the moment. Whatever he considers to be important, he'll fish out the report and bring it to cabinet. In terms of the strategies, we've tried to lobby, talk to the Minister of Justice, talk to the Ministry of Justice in terms of the Solicitor General and the people in the drafting section, because they're the ones who are supposed to adapt the bills and bring them to the attention of cabinet. We've also insisted that every time cabinet meets to discuss bills from Law Commission, we should be present to speak to the bills and emphasize the importance of whatever we are proposing. The other strategies, the usual one of using parliamentarians and the civil society to lobby. Sometimes civil society has taken on board our proposals and pushed forward reforms. So that's what I think we've been doing as an institution. Otherwise, our hands are very tied once we submit the report to cabinet and parliament. We just sit back and wait. They love it, they don't. Yeah. I think
Okay, that's really it.
Impact assessments.
If that's all right.
Yes, impact assessments are quite new to us as a law reform body. We've just begun doing them over the past 2 years, and we're very inexperienced at it and learning as we go. But it has been a request by the government to us, and it's part of the shift, as I mentioned earlier, of perhaps seeing less resources within government or within Parliament, and so for law reform measures they'd like to shift some bonus back to us. But there's a great interest in Parliament for assessing the impact of any change in the law. The Parliament wants to be convinced that all options have been looked at, including the option of do nothing, but also if you take one of the law reform recommendations, what's the impact on business? Is it going to cost more? What's the impact on minorities or island communities, rural communities? So the impact assessment has to cover all these areas, and because the Parliament is interested, the government want us, when we put forward our recommendations and our bills, to have at that stage prepared an impact assessment to say what would happen if you implemented law reform recommendations. Now this actually involves quite a lot of form filling, and a lot of you need evidence on the impacts, and it involves, say for example, impact on business, engaging with a sample of perhaps 6 to 8 of the affected types of business of any reform, and engaging with them to get them to give us costs and feedback and evidence for what we then say is the impact, and that will help, for us, will help smooth the passage of our bills within the government and the Parliament. So that's the new thing. I know the Law Commission of England and Wales is a much bigger organisation than us, and they've employed a couple of analysts to help with the impact assessment work. For ourselves, we are a very small body. We can't do that, so we're trying to bring in analysts from government to help us with this.
Malcolm, can I cheekily chip in here? While you're in full flow, could you say perhaps a little more about your relationship with Malawi? I mean, a lot of what you have talked about is our experiences in common.
Yeah.
But how this is developing and what what, if anything, you've learnt from them, and what, if anything, have they learnt from you, and how the link is actually working, because I think this is a fascinating partnership between the two.
Yes. Well, it was certainly a new development for us. As law reform bodies, we're used to meeting each other at conferences or having study visits to each other to try and learn about how we go about things. But what was envisaged here by the Scottish Government was a specific relationship between law reform bodies, and equally envisaged, I think, by the Malawian Government at your end. As I said earlier, it's difficult to give expression to it from a distance, and that we try and do. And the whole thing is we're not expert in Malawian law, neither you in Scots law. We can't do joint projects, but nevertheless we share some fundamental concerns about promoting law reform. So, do you want to say do you want to say anything about it? No.
Go ahead. Go ahead.
Well, I suppose what we've done, two of our lawyers were in Malawi last year to deliver training requested by the Malawi Law Commission, which is one in project management, and which I think was useful because the context was law reform projects, so we're speaking the same context and understanding, and also some development in legal research techniques. Yep. In addition, one of the Malawian Law Commission's projects is intellectual property, a review of the law to lift up to, I suppose, international standards in terms of international conventions. And we have one of our former legal research assistants who's with the Malawi Law Commission on a part-time basis and has been there for 2 years now. And he's gone Malawian, basically. He loves it there. And he's there to help capacity to be a member of the law reform team, the research and work. And also we offered the expertise of one of our commissioners who's got an international reputation in intellectual property law, cost-effective measure in a kind of e-relationship. He offered to review papers that were produced, if that would be helpful to the Special Law Commission from the point of view of his expertise. He's done that once. Apart from that, it's been general, just meeting together to talk. Myself and our previous chairman went out to Malawi last year, and the visit centred around two keynote addresses. One to promote law reform in front of a very distinguished audience, I think, in Malawi. And then secondly, to set, before mainly the judiciary, to promote the idea of judicial training and set the scene for the judges in Scotland and Malawi to talk and begin to have a link. And hopefully soon the judicial training unit, a senior judge in Scotland and a full-time director will be able to go to Malawi and talk about what they can do to help with the judicial training programme in Malawi. Because as your booklet points out, to the absolute fundamental importance of the judges in Malawi. So that's it so far, really.
Thank you. I think that's very helpful, though, to hear the nitty-gritty about the relationship. Would you like to comment as well?
No sooner have you suggested. I don't take it personally. Can I just sort of come in on what...
Sorry, could you just introduce yourself, Michael, as well? Thanks.
My name is Michael Sayers. I'm the General Secretary
Thank you.
of the Commonwealth Association of Law Reform Agencies, which is a modest little organisation which has about half, or rather more than half, of the law reform bodies there are around the Commonwealth, mainly in the Commonwealth and beyond. There are over 60 such organisations, like both the Malawi Law Commission and the Scottish Law Commission, and they are pleased to say both members. So that's my sort of interest. Our strapline is encouraging international cooperation on law reform. So I'd like to welcome warmly Janet's paper and her, if I may say so, rounded and robust presentation, and Malcolm's very interesting insights too. My particular interest in Malawi, though I've got quite a number in their law commission and law reform, is that I was asked by the Malawi Law Commission to conduct a joint review of the place that Janet worked. She absolutely absented herself at the time, was working on her PhD over here, but and we produced a quite substantial report with quite a large number of recommendations in 2010. But basically, we were pretty impressed by the Malawi Law Commission, bearing everything in mind around their circumstances.
wrote a generally supportive report, and many of our recommendations were not so much to them as to the government, but there were certainly some to them. And so that's the sort of background. If any of you are interested in law reform, particularly interested in law reform and the sort of mechanics of it and so on, my little modest organisation has been, I think, surprisingly successful considering our tiny size in a number of different areas, ranging from training in methodology for law reform, the sort of things that Janet was briefly summarising, in things like conferences. I've got the flyer for our next conference, which is in South Africa in next April. Links to the Commonwealth Law Conference, which is a very big legal thing. And also, to my amazement, quite a good deal of overall support of the law ministers of the Commonwealth, which I'm hoping will continue to bear some sort of a fruit. So I've got a few flyers with me. I've got our brochure. I've even got the flyer from the last training course that I was involved in, which looks like that. I call it the Pink Peril, which Janet was going to come on a couple of weeks ago, actually, but sadly, for personal reasons, couldn't. I thought that she should be conducting it, but actually, she was coming. She was going to come on it. I don't know if you'd like me just to say a touch about international cooperation. I'll leave that. Shall I tell? If there are other people who may want to contribute.
Does anyone want to chip in right away, or can we hear about international cooperation? Yes, we can. But very briefly, please.
Yeah, very brief. Well, between the two of them, they've outlined some of it, and the fellow in the front row, Jarvis Mataya, has as well from the Commonwealth Secretariat. But there is a good deal that can be done. There's what Malcolm described as plagiarism, legitimate plagiarism. That's to say, not reinventing the wheel. Who's got a dog with them? And there's visits and that sort of thing. There's what I think of as something approaching twinning, which is what I regard Malcolm's and Malawi's relationship approaching twinning, like we have in many towns and villages in this country. It's not quite as much as that, but it's going that way. So there's quite a lot that can go on, apart from much more personal contacts, and also the contacts, which is very important, which comes into the plagiarism category, learning from each other's work in particular areas of law. That's one of the most important ones. When I conduct a training course, I always say, do not try to reach even basic proposals, however developed or undeveloped your country, until you've had a good look round at countries that are somewhat like yourselves, who have legal systems a bit like your own, to see where they've got to on this particular subject. What have they done, what have they rejected, and so on. And you may be able to take quite a bit from them, or learn from what they've rejected already. I'm very happy to elaborate. And if you would like to have any bumps to take home, I've got some.
That's extremely kind. Thank you very much. Janet, would you like to respond to what both Malcolm and Michael said as well? In terms of the, well, for example, with Malcolm to the link with Scotland, is there anything you'd like to add? Or
that has been very beneficial to the Commission, especially in terms of technical support.
Right.
Yeah, I think it's a good thing, and I would encourage. I would encourage them, because especially for technical areas that are not traditionally, handled by African law commissions, law commissions in Africa. I think I mentioned one area in an email to you. So you remember, it's about, of course, the usual thing about oil and whatever. Yeah. It's a new thing for Africa, and I think
right.
Technical expertise would come in hand in such areas. But otherwise, I think I've worked with Michael Sayers. I've met with Michael Sayers, I think, on a number of occasions. I know he's promoting a very good course on law reform. Hence the pink flyer. It has come in. It has been recommended very highly by those who have attended. So, congratulations for that. That's why I was so keen to come and attend. Otherwise, I think the comment that was made by Professor Nkandawire, I took note of that. I think
we all did. Yes.
It would be a subject for separate debate between him and me.
I think so. If I could just say, actually, picking up on what Professor said about the hopeful things and the positive things, of which there are many. We will be continuing this dialogue in Lilongwe next week. So I just want to say that before anyone else leaves. Exactly 7 days away, we will be launching the publication in Lilongwe, and we're extremely grateful that the Attorney General will be there to respond, so we're getting right to the heart. And Justice Twea will also be on the podium to respond, and we're expecting a very full audience. So this dialogue is going to continue, and we hope that it will be heard by government, because that is I think a refrain that's coming up frequently. Whether that achieves anything, we will see, but at least it will be heard. Would anyone else like to contribute? What we can do is call a close and then just carry on informally. There is coffee available outside. I'm sure there's plenty of food still left, and you're all more than welcome to stay for as long as you like. I would just like to thank both speakers very much indeed. I think this has been an absolutely fascinating topic, and I personally feel very fortunate to have two such prominent practitioners explaining this business of law reform, which is perhaps something that is maybe not the sort of maybe not the sexiest of areas, as it were, and often under the radar, but critically important, really, to the functioning of democracies. I think that considering the obstacles that the Law Commission has come up against in Malawi, it is actually, and Janet has been extremely frank about what those are and their magnitude. I again personally think it's pretty remarkable what has been achieved. I mean, she has not talked in detail, because time is short, about, for example, the immense amount of work that the Law Commission has done in reforming the criminal justice system. Wholesale reform of the penal code, which was completely out of date and inherited from both colonial times and then an authoritarian single-party state. So really, the law reform has been pursued with great courage, I think, in Malawi, and it is to the credit of Janet and her colleagues that is the case. I would just like to end, perhaps, by slightly paraphrasing a statement of hers in a paper from a couple of years back, which went along these lines, that institutionalised law reform does not ensure consolidation of constitutionalism, nor does it guarantee the rule of law and democratic governance. However, the absence of systematic law reform may limit severely that possibility and can at worst impede the achievement of these aspirations. Now, I think that's where law reform fits into all of this. Miracles will not be achieved, but it is very important that it is there and conducted in a professional manner. I would like us all to show our great appreciation both to Malcolm and to Janet. Thank you very much. And you're all welcome at the Sunbird Lilongwe this time next Thursday, if anyone can make it. We'll probably have fewer problems getting there.
I think I always have to say I am so sorry. I flew in 6 airport and probably half because push it.
Yeah, this one. Which one?
It's the only flight I could get back.
Yeah.
I'm afraid.
I'm afraid.